Brian, as we mentioned, we're recording this so that we'll give you a link that you can share with the other members. We did receive some responses from a few folks who said that they were interested, but were unable to make it work with the time today. So you'll be able to just share that link out to whomever, to anybody that you have in the group.
Yeah, thank you. That's very much appreciated.
We will get started, everybody, in under a minute. We'll start at 2:05. And it's 2:05, so we'll get started. Brian, did you want to do any open intro, or do you want me to just jump right in?
No, I mean, I would just, start by saying thank you for taking the time to do this for the National Association of Probation Executives. We always try to, I think, reach membership with, practical kind of substantive things that will help any executive across the country, get their agency to a better place. So, I immediately thought of you all at the Council of State Governments and the work, you've helped us with here in Massachusetts, and especially on this particular project about the national guidelines for post-conviction risk and needs assessments, and knowing how much of a help you've been, here in Massachusetts to us as a system, kind of a large statewide system, in our efforts to get, our use of the ORAS revalidated, and, really help improve our communication with, not only individuals we have on caseloads and work with to, hopefully, catalyze some positive behavior change, but also, judges we work with every day and the legislators we work with every day, as well as just the general public. So I'd say thank you. And yeah, again, thanks for joining us and doing this for us.
Certainly, no problem. Happy to do so. My name, folks, is David Demora. For those of you that I have not met, I'm a senior advisor at the CSG Justice Center. I've been here for just under 14 years, after about 35 years in the field, working pretty much the intersection of behavioral health and criminal justice, a lot of work around violence, different types of violent offenders, and a lot of work with risk and needs assessment, specifically post-conviction risk and needs assessment. And I am here with my colleague, Kendra Carroll. You want to introduce yourself, Kendra?
Sure. Thanks, David. Hi, everyone. My name is Kendra Carroll, and I'm a policy analyst at the CSG Justice Center, working alongside David on several projects around the Justice Reinvestment Initiative. I mainly focus on analyzing policies and procedures and assisting with technical assistance to improve agency practices. Prior to the Justice Center, I spent over 7 years in direct service, working in adult reentry as an intensive supervision officer with the South Carolina Department of Corrections and with court-affiliated youth with the Kentucky Court of Justice. Impacting systematic change is a passion of mine, so thank you for letting me and David speak with you today.
So our plan today, as soon as I get my mouse to work the way I want, our plan today is to really talk to you about the national guidelines. We're going to talk about why we worked on this, why BJ asked us to take a look at this. We're going to talk about how we got to them. We're going to talk about what they are. And we're going to talk about the fact that there are some technical assistance opportunities for folks who may be interested in working on one or all of the guidelines. It's not an all or nothing option. Some states that we're working with have decided they want to work on all of the guidelines. Some states have said, no, right now we can only work on one or two, and these are the ones that we'd like to work on now. So we'll talk about how you can fairly easily apply for that technical assistance should you be interested. Start, as I said, with why the guidelines, why the need for them. And the fact of the matter is that and forgive me, I have to also get rid of my little screen there on the side. So I cannot see anybody, Kendra. So if there are any comments, be kind enough to just let me know, okay? There really is a need for a standardized approach to risk and needs assessment tools across the nation because, frankly, people are all over the map with it. They're developed and used differently across the country. Frankly, they're developed and used differently within states from county to county in many instances. States certainly do want to ensure that the assessment instruments does not increase disparities within the system, and there are definite concerns and perceptions of unfairness that have developed over the last 5 to 8 years, in particular, concerns over a lack of transparency, concerns over what people sometimes call secret algorithms, if you will, and concern that despite the best of intentions, that the use of these tools doesn't actually decrease the disparities that are frankly rampant in the system, but that it potentially could increase them. When we did a survey a few years ago in 2017, we found that in fact 48 states reported using risk assessment instruments for their folks that were on parole. 2 of the states at the time did not have post-custody supervision populations, and therefore they didn't use risk assessment. When we looked at that in terms of probation, 45 states, so 3 less at the time, reported using risk assessment instruments for people on probation. 5 states at that point either did not respond, reported that they were not using risk and needs assessment instruments, or, and I find this one a little head scratching, to be honest, did not know if they were using risk and need assessment risk instruments. Coverage on the tools began to fuel concern about disparate outcomes for folks of color. The Marshall Project put out a study, can racist algorithms be fixed? The Philadelphia Inquirer was concerned, and folks in Philadelphia, around the development of a risk assessment tool that they are indeed using in Pennsylvania, with critics saying that it is a racist tool. Boston Globe talked about the potential for discrimination in the age of algorithms. And then you saw some sort of other side arguments coming back, if you will, in Law 360. Risk assessment tools are not a failed minority report. And the crime report, no evidence of race bias in risk assessment, again, based on a guest editorial for the crime report. So a lot of arguments back and forth, and very genuine and appropriate concern, right? In terms of pretrial risk instruments, algorithmic decision-making tools are only as smart as the inputs into the system. Biases in data sets will not only be replicated in the results, they may actually be exacerbated. And then Senators Cory Booker, Richard Durbin, and Kamala Harris, as well as Representatives Sheila Jackson Lee and John Lewis, put out a relatively lengthy statement. But to boil that down here, research shows that risk assessments often do not accurately predict risk and can produce results that are biased against people of color, particularly African Americans. The concerns are valid and genuine, though unfortunately in many instances misplaced. In many instances, what you saw were attacks on the tools when in fact the bigger problem was the way people were using the tools, that they were either using them inappropriately for the wrong things. They were then making decisions that the tools were not designed to help make, or they were simply not scoring the tools correctly and making a large number of overrides to the results of the tools. So the concerns about can this make things worse are valid. We have a lot of studies now over the last several years that show that most of the time the problem is not within the tool itself, but within the implementation and use of the tool. Now, there are some exceptions to that. It is true, in fact, that over the past 35 years, many instrument validations did not include a statistical test for accuracy across race, ethnicity, and gender, but the field is clearly shifting in this area. When we look at a number of the studies over the last 5 years, they're very much looking at the differences in how these tools might be predictively accurate across race, ethnicity, and gender. And with some of the big name tools in particular that they've done studies on, while they have found a slight variation, they haven't found variations that are statistically significant. What they also have not done, however, is explained this very well. And so it's all fine that it gets into a professional journal article and, the folks that do this day in and day out read that, but it has not been very helpful in terms of the general population understanding this. There's also been a lack of transparency in explaining the instrument's use. What is it being used for and why? What decisions do we make? As well as the fairness. How do we describe that? How do we show what that means? As well as accuracy of the instruments to people who undergo the assessments and to the broader public in particular. So the guidelines basically pose three questions to help policymakers and practitioners. It looks at, first of all, what's the degree of accuracy that a post-conviction risk and needs assessment instrument should meet? Because, of course, there is no such thing as 100% accuracy, but we certainly want improved accuracy over clinical or professional judgment, which in most instances is not better than chance. Secondly, how can users best determine the fairness of the instruments across race, ethnicity, and gender, especially given the history of bias and disparities in the criminal justice system? And again, it's not just the fairness within the instrument, it's how we utilize the instrument and the decisions that we make as a result of the instrument's scores. And then in what ways should information about the use of those instruments and their underlying algorithms be transparent and communicated publicly so that folks actually know what's going on? Unfortunately, a number of the tools, and again, this is changing as well over the last 5 years, but historically, a number of the tools which were particularly connected to basically places that made money off those tools, you had to pay for each use of the tool, were reluctant to give out the underlying algorithms, basically seeing it as a problematic decision in terms of their business model and allowing others to copy that, if you will, those algorithms. But in fact, it is imperative that people know what's under the hood so that they can trust what is there and know how decisions are being made. So the methodology in terms of looking at and developing these guidelines was, first of all, taking a look at the current state of the field. Of course, we did a foundational survey, developed definitions of fairness, accuracy, transparency, inter-rater agreement, fidelity, and validation and revalidation, because it won't surprise you that folks had different views and definitions about what those things meant. We then really looked at parsing out fairness. That was a very big issue in terms of discussion about what does fairness mean. Improving equity and considering the context of the tools. Again, the issue of how they're used and how decision-making would ultimately be impacted by the use of the tools. We then looked at a consensus survey, or rather developed a consensus survey, 6 questions defining risk and needs, improving equity and risk and needs assessment, the context to consider. And then last but not least, looked at the effectiveness of communication. And all of this was done with an advisory group of about 26 individuals to ultimately get to the proposed guidelines based on consensus over the highest ranked factors. And as you can see here, there were a large number of individuals that we worked with. You no doubt know some of these individuals. We certainly chose folks who are big in the field in terms of risk and need assessment, but we also chose people who are practitioners. We chose some folks who are not in the field itself, but have done some research. In other words, not test developers, but folks that have done some independent research on the tools. We also wanted to make sure that we had administrators available and folks who worked in the field, not just in corrections, if you will, or not just in probation and parole, rather, but in the larger field of criminal justice. And we were fortunate to get a good number of these folks here, as you can see. And many of these folks we still are in regular contact with as we move forward in this process. The guidelines designed to help address gaps in how the tools are administered, as well as providing additional benefits, better decision-making, increased accuracy, reduced bias, and obviously, as is our job, the promotion of rehabilitation and public safety. Now, to be clear, these guidelines are related to post-conviction risk and needs assessment instruments in order to inform the decisions and case planning that occur after court disposition, after conviction and sentencing. And they're focusing on that, one, because that is the most broad use of risk and needs assessment, but also quite bluntly, because that's what we were asked to do. The Bureau of Justice Assistance wanted us to focus on the areas that related to the community supervision of individuals decision-making about what they needed to be doing on supervision, and less so on the narrower field of pretrial risk and needs assessment. Now, the guidelines can also be used in the application of assessment results to inform decision-making and case planning in the context of alternative forms of criminal justice processing, such as diversion programs that folks might happen. And so these can be used for pre-sentence investigations, right? They can be used at the time people enter into probation. They can be used when there's a decision being made about diversion and what kind of diversion program might make sense to offer. So the guidelines basically launched in August of 2022, so almost 2 years ago, in the midst of COVID, on BJA's Public Safety Risk Assessment Clearinghouse website. This was after about 2 years of work with the advisory group, and that work was all virtual again because of the situation that developed with COVID. And so therefore, we held virtual meetings. We did those meetings with our advisors. We did those meetings with outside groups, advocacy groups for those who have been impacted by crime, advocacy groups for those who are in the criminal legal system. We had several meetings with other folks who were practitioners, but who were not on the advisory group. So we wanted to make sure that we had a wide variety of individuals. We also had some focus groups with people with lived experience and wanted to hear their stories in terms of what went on for them and how they were impacted by the use of risk and needs assessment when they were under supervision. There are 4 sections to the guidelines, so 4 overarching global sections. The first one is accuracy, specifically predictive accuracy. If you don't have accuracy, everything else, of course, falls down from there. The second set of guidelines has to do with the issue of fairness, making sure that 1, the tool is fair, and 2, how the tool is utilized is fair. And one of the many ways that you think about that is, of course, then looking at the issue of transparency, making sure that people understand what's under the hood, understand what the tool is used for, understand what it is not being used for, understand what its limitations are, as well as what it brings to the table to help us have good decision making. And then lastly, communication and use. Use is obviously implementation, and communication really focuses on the fact that those of us in the field talk about this all the time. And we have the language, and we have the knowledge, and we have the sort of underlying information of years of experience with these tools. But when we talk to other folks who haven't been using them day in and day out, who weren't around as we developed these things and as we figured out how to utilize them, we sometimes talk to them in ways they just don't get what we're saying. They don't understand. And that can be legislators, it can be judges, prosecutors, defense attorneys, people in the community, the people that we're evaluating, their families, or just the general public. And so part of the guidelines really looks at and relates to this concept of how do we develop appropriate communication for different groups, for different stakeholders, not just appropriate communication within our world, if you will. So when we talk about accuracy, it refers to the degree to which assessment results predict the recidivism outcomes that they were in fact designed to predict. There are 4 guidelines that we talk about here under accuracy in particular. The first one is the need to have a local evaluation of the risk and needs assessment instrument to make sure it's suitable for the agency's population. Still today, a lot of places either develop their own tool and don't validate it, or they take an off-the-shelf tool that indeed has been validated in other jurisdictions or validated with the original samples, whether that's the ORAS or the LSIR series or the Compass or a number of other things. But places will often take that tool, use the quote off-the-shelf tool, and may not validate it locally. And the upside of the fact they've been validated in their development is that you are using a tool that has been shown to be useful and appropriate and accurate. The downside is if it hasn't been locally validated, your accuracy is going to be less. There may come a day when the sample sizes are so large and so broad, we won't necessarily need to constantly do local evaluations or local validations. But that day's not here yet, and I don't know when or if that day will come. Secondly, that the accuracy guidelines say that the tool needs to meet minimum performance thresholds of the post-conviction risk and needs assessment that are completed in the field. So in other words, there needs to be a certain level of accuracy, a certain what we call area under the curve or predictive accuracy in the use of the tool. Third, there needs to be a CQI process in place to make sure that there's successful implementation of the tool. This is the second big place, quite frankly, that systems, jurisdictions fall down. I've worked with a number of places that the first thing that goes when there's a funding issue is the quality assurance component. Or they put in the risk and needs assessment, but they don't develop an ongoing coaching and quality assurance component. And when that happens, no matter how good the initial training is, there will be drift, and it comes awfully quickly, that drift. And so there needs to be a CQI or continuous quality improvement process in place with ongoing coaching and ongoing retraining of individuals over time. And then fourth, using a multi-step approach to assess risk and needs over time, which simply means it's not a one and done. You want to have a tool that you can utilize to make an assessment and that you can then utilize later. Some folks do this every 6 months, some folks do it every year, depending on whether or not there isn't a large circumstance change. If there's a large circumstance change, a new arrest, for example, or perhaps a violation of probation or parole, then they might use it more often. But the main point here is it's not a one and done. It's something that needs to be done over time, which means that you want to have a tool that is capable of looking at change, as opposed to simply a static tool that will not change over time. Now, there are some tools for special populations where they've developed separate tools for that. A tool that here's your initial static kind of assessment of what's going on, and then there's a different tool that's related that you would use to measure change over time. But in either case, whether it's the same tool or it's using a couple of different tools, you want to be using an approach over time where you are continuing to reassess or reevaluate clients. When we talk about fairness, fairness is the degree to which assessment results have the same meanings and applications across groups that are defined by race, ethnicity, gender, or other characteristics such as mental illness, for example. And when we look at guidelines under the area of fairness, and there's a total of, if I didn't say this already, there's a total of 13 guidelines in these 4 buckets. In the fairness guidelines, we're looking at examining the results of the post-conviction risk and needs assessment instrument for predictive bias and disparate impact across groups. And both of those are important because it is possible that the instrument does not have predictive bias. It can be fully accurate, but it can still have disparate impact across groups, because the reason that one group versus another is going to come out as higher risk, it may be a valid, accurate find, but the reason they're coming out as higher risk has to do with how their local police department behaves or how their local judiciary behaves, and that it's an external increase of their risk, not an internal in the sense of their own criminogenic factors increase. There's a number of ways the tools are really beginning to look at this. One is by weighting certain responses differently. In some cases, dropping certain questions that don't lower the predictive accuracy, but lower the potential for the disparate impact. So there's a number of ways to go about really assuring the minimization of predictive bias and the minimization of disparate impact across groups. And sixth, applying the instrument results to individual cases and keeping with R&R principles. There's an interesting thing happening right now in criminal justice, and this is true all the time. I've been around for 45 odd years here. And, we all see changes over time. And of course, those of us that have been around long enough remember when the R&R model came in. And when that came in, we threw a lot of things out. And over time, what we realized was that we threw a lot of things out that actually fit in the responsivity bucket. And that if we're really going to be effective in terms of looking at criminogenic needs and making differences, we need to be better at thinking about what the responsivity factors are. And we've sort of learned that over time. But as that's also been happening, we've also learned a lot about the impact of trauma on individuals who are in the criminal legal system. Very valid. But you're seeing some places now say, we're going to drop the R&R model. We're going to go fully with something like trauma or the mental health or ecological components. And I would strongly argue that that's a very bad decision, that those things are massively important. They very much fall in the responsivity component of what we need to do. And in that responsivity component, there indeed may be other kinds of programming people need in order to be well. But if they have high criminogenic need, those other responses will not resolve that component. It's also true that if we don't resolve those other issues, if we don't work with individuals' trauma, for example, then no matter how well we do the cog programming with them, that's not going to resolve it by itself either, because we haven't dealt with many of those things that get in the way, if you will, of them being able to improve. It's one of the reasons why when we look at cog programming, we see a 25% reduction. That's good. It's better than we ever had before. Needs to be higher. And the reason that it's not higher is because we are only now coming to grips with the fact that we need to be so much better in the responsivity component of our assessment and our program planning and our service provision. And then thirdly, adopting agency-wide strategies to minimize the potential that local implementation does not promote disparity. So that's sort of the opposite of that, right? We want to really look at, from a strategic point of view, what's happening in our locale. What is going on? What's the difference in terms of perhaps what's happening in Boston in terms of law enforcement versus what's happening in the northwest part of Massachusetts in terms of law enforcement, or even here in Connecticut, where I'm talking to you from? Small state, unified system, massive differences if I'm in court in New Haven or I'm in court in Litchfield County. And so we really need to be looking at those. And those are agency strategies. Those are not things that relate to the tool itself, but relate to how we think about the results of the tool, the scores of the tool, how the system impacts the outcomes and the use of that tool. Third area has to do with transparency, which refers to how information about the content, structure, and application of the instruments is disseminated to folks. How do we talk about it, right? And again, some guidelines here. Providing the system stakeholders with the relevant information on how we developed the tool, and if we didn't develop it, how it was developed, what our intended use is, what we will use it for and not. I still see many folks use results from risk and need assessment tools and make a statement about whether somebody should be incarcerated from the use of that tool. They weren't developed to do that. That wasn't the point. That wasn't the idea. And yet we see that happen many times. We need to be very explicit in, one, what the tool was designed to do, and two, how we intend to use the results of those tools. And then, of course, the validation or revalidation of the tool. We need to be able to explain to folks, this is how it was developed. This is what it was intended to be used for. This is what it is not going to be used for. And this is how we are making sure that it is as accurate as it can be. It needs to be a written policy that guides the local use of the risk and needs assessment instrument, and that policy should be consistent across the state, across the different systems in the state. I'm working in one state where there are 3 different delivery systems who are providing community supervision, and historically, while there are a lot of things they do the same, there have been some substantive differences between how they approach certain things, and that's problematic. It ended up with what we saw, where people had different risk levels based only on where they happen to do the tool, not based on their actual internal risk, but based on the different cutoff scores that people decided. And those cutoff scores were not based on the science within the tool, but were based on the resources that were available to a particular jurisdiction. So they adjusted the cutoff scores to meet their what their resources were. There's sort of 2 problems with that. You're now actually measuring the system, not the individual, is one problem. And I would also argue it doesn't give you what you need to argue with, and I use the word argue in a positive sense, to argue with legislators and those who are responsible for thinking about funding and resources when we sort of, cheat isn't the right word, but when we make it look as if we can meet the need of this group because there's only this many. when in fact there's only this many because of how we did the cutoff score. We're sort of cheating ourselves over time. We're not giving a good message, good information about what the reality of the problem is. And we're kind of shooting ourselves in the foot by not gathering that data in a way to really show folks what our needs are. And then again, communicating the strengths and the limitations of post-conviction risk and needs assessment instruments to the general public. Like, they're not magic bullets. We do know that they are much better than us. Again, I've been around long enough that we used to do this stuff before these tools existed. And I assure you, our decisions were not better back in those days, whether it was us doing supervision or programming, or whether it was the folks making judicial decisions. This is definitely, when we follow them, definitely improved our judgment and our decision making. And then communication and use, which refers to the fact that the manner in which the results are communicated and used can greatly affect their impact on decision making and therefore their effectiveness. And so we want to make sure, again, that the communication of the results are anchored in R&R principles. Here's what the results are, Joe, as opposed to, well, you're high risk. That's not very helpful, right? We want to anchor the communication of, here's where we saw there are some significant needs. Here's why we think we need to be resolving those needs. And we realize we cannot maybe meet all of them right away. So together with Joe, we figure out which one shall we start with, which one shall we work on. This, of course, is assuming that one of these needs isn't a threat to public safety that is immediate, in which case, obviously, we're going to have to choose to deal with that immediately and then loop back, if you will, to the others. But we should be talking with our clients about why it is we're doing this, and that it has to do with really helping resolve some of the needs they have. I would also argue that we should be talking to judges, prosecutors, and defense attorneys in a similar way, even though we'd be using slightly different language. And then need to contextualize the results of the post-conviction risk and needs assessment instrument. Again, this is what it means. This is what it doesn't mean. Here's what we're going to do with these things. And then developing a template for communicating the results to all the relevant stakeholders. I've mentioned multiple stakeholders several times now. And in fact, one part of our project is the development of templates for these different stakeholders. And what we'll have are templates that, if you're talking to a judge, if you're talking to a legislator, if you're talking to a prosecutor, et cetera, et cetera. And then those templates will give folks the overarching components, which can then be personalized to your particular state, because there obviously are some differences from state to state, and the way that judges and probation supervisors communicate in one state may be somewhat different than in another. And so we want to be able to give people the baseline of what it is they can use and give them room to be able to then personalize that to their particular state. So with that, we're going to talk briefly about the practical application and then the next steps in being able to apply for technical assistance. And my colleague Kendra will pick it up from here. Kendra, I'll just keep pressing the button unless you also have sharing ability.
I will let you press the button, but thank you, David. So now that we've looked into the guidelines, let's look at the various benefits of our technical assistance opportunities. In terms of an organizational standpoint, looking at clarity, adopting the guidelines ensures that your instruments and standards are both fair and transparent. By making these small enhancements, specifically around reducing disparate impact, agencies will begin to see assessment results that more accurately align with their population's criminogenic needs. In terms of competency, we really want to emphasize the communication guidelines here. Our TA is designed to help agency staff become more proficient in implementing assessment results in their case management processes. We strive to enable staff with the skills to effectively answer questions about their instrument and also to communicate how the results are being used throughout the reentry process, especially for members of the community who may not be as familiar. So how do we do that through our TA? David kind of just touched on that, but we worked specifically with each agency to develop tailored, standardized templates for effective communication around these processes for various audiences. So clients, community partners, judges, law enforcement, a multitude of audiences, but this is to increase transparency and understanding in the community, ultimately achieving better outcomes and enhance public safety. In terms of fidelity, we work closely with agencies to ensure specific implementation strategies are in place, even long after RTA is over. We make sure that the agencies are in the best place possible to carry out the guidelines. Looking specifically at resources, the implementation of the guidelines designed to enhance fairness and transparency, allowing agencies to make more informed decisions around case planning interventions just by reducing the likelihood of biases or disparate impact. I'm sure most of us on this call are already aware that when we're able to accurately identify our higher need clients, we're then able to allocate resources more effectively and ensure that interventions are being targeted where they're needed most. And having this evidence-based approach allows our agencies to optimize their resources, focusing on clients who will benefit most from intensive interventions and supervision, and reducing the potential for over-servicing lower need clients, causing a counterproductive effect. And lastly, in terms of organizational benefits, each of these benefits: improved communication, fidelity practices, resource allocation, more informed case planning, they all contribute to helping agencies achieve better outcomes. And you can go next slide. Thanks, David. So now let's shift to the benefits from the client perspective. First, we have mitigation of bias. So when agencies are able to identify and reduce biases within their instrument and processes, the disparate impact decreases and the accuracy of their results increase, and they're ensuring that their clients are receiving the most appropriate and targeted interventions that align with their individual criminogenic need. In addition to reducing bias, we now have a deeper understanding of the client and the context behind their system involvement. From a former client perspective, these assessment results directly highlight our clients' trouble spots, which I always viewed as a direct opportunity to better understand and address their root cause of criminal behavior. Thus, the underlying foundation of the guidelines, the more accurate and precise our tool is, the more informed and effective our decision-making will be, which then leads us to results. It is extremely important, as we all know, to meet people where they are. As all of us have probably heard at one point in our careers, results are not just for the case file or to merely check a box. These results must be used to inform case planning decisions. And our TA focuses on meeting agencies where they are so that they are better equipped to meet their clients where they are more effectively. And then lastly, with clarity, consistency, and transparency, all of those play a role here in terms of client benefits as well. Clarity in guiding agency staff on clear and transparent communication, consistency in ensuring fairness for all clients, specifically around reducing those biases and increasing inter-rater reliability, and helping just build rapport and trust between clients and staff, and also the agency as a whole. And then transparency, open dialogue and transparency behind these decisions gives the client a sense of autonomy in the process, which in turn leads to increased cooperation and commitment and likely better outcomes. Next slide. Thanks, David. Moving over to stakeholder and community benefits. As we stated previously, the benefits associated specifically with our stakeholders and communities are heavily dependent on our ability to effectively communicate, specifically around our ability to explain how these tools are used on a larger scale that is relatable to the community, and how the results are used in strategic ways to ultimately increase public safety. I'm confident that many or most of us on this call today have had some interaction with a member of the community, a valued stakeholder, regarding the processes around the use of risk and need assessments. With that said, let me throw out a rhetorical question. Would additional guidance around communication have helped you navigating those scenarios? How about your staff, the boots on the ground? Increased communication on the community level offers stakeholders the opportunity to be involved in the process, allowing them to establish a deeper understanding of the purpose, use, and limitations of our assessment tools. It comes as no surprise that a large percentage of members in the community often associate the designation of high risk to mean high risk of violence, which we all know is a false narrative, but to someone less familiar with best practices and correctional terminology, it seems legitimate. We have to remember that our language and processes are second nature to us. However, for most members of the community, these processes are extremely unfamiliar. So it is our responsibility to educate our stakeholders and members of the community around what we do and the evidence-based reasoning behind our decisions. The more informed our communities are, the better they will understand, and it reduces unnecessary confusion. And this is an extremely crucial aspect of our TA process. We work closely with agency members to develop the most impactful communication templates, as David mentioned, for a multitude of audiences within their specific jurisdiction. And next slide, David. And lastly, in terms of the benefits, let's look at the research practitioner side. The guidelines aim to provide researchers and practitioners with concrete guidance on evaluating to what degree their risk and need assessment standards actually align with best practices. Our TA efforts heavily emphasize the accuracy principle of the guidelines by assisting agencies with the validation and revalidation process in order to ensure that the instrument being used is the most appropriate for that population. Just like each individual client changes and evolves throughout the supervision process, our communities also change over time. So it's essential that our instruments adapt to meet those evolving needs. So by continuing to evaluate our tools, as well as our policies and procedures, we're aligning with sustainability in terms of continuous quality assurance. Making these adjustments provides agencies with the most accurate instrument in terms of validity and appropriateness for their specific population, which is a necessity for improving outcomes as a whole. And next slide, David. Okay, so now let's go over some resources. Here we have 5 tangible resources available in addition to our technical assistance. On the screen, you will see a screenshot of the main website for the project. These resources, the guidelines themselves, were developed with a variety of audiences in mind. With that said, among those resources, you'll find a pair of FAQ documents, one for legislators, one for agency administrators, and an executive summary document aimed at practitioners and researchers, and, a longer deep dive publication aimed for researchers and others charged with implementing the guidelines in their agency. The 5th resource, which I'll talk about in a second, is a self-assessment tool, one that we use for you to rate your alignment with the guidelines to help us tailor our technical assistance efforts. And you can go on to the next slide, David. So our self-assessment tool is designed to assess the status of your efforts in preparation for adopting the guidelines. You will rate each of the guidelines and their components on a scale ranging from not planned to fully implemented. We recommend that the self-assessment be completed by those specifically responsible for selecting or implementing their agency's instrument, developing the related policies, and making the decisions regarding their use. We also recommend that the self-assessment tool be completed at multiple stages to track implementation progress over time, which is another focus of our technical assistance as well. And as you can see on this, can you take it back?
Want me to go back?
Yeah.
I'm back.
As you can see on the slide as well, you can access the self-assessment tool following the link at the bottom, which I can drop into the chat as well for easier access. And when you complete the self-assessment tool, your submission comes with a report that is available to all agencies who complete the self-assessment, and it provides a summary of your results, and it also provides our project team with invaluable insight into how we can tailor recommendations for each agency. Next slide, David. As far as requesting technical assistance, as David said earlier, our TA is not a one-size-fits-all approach. All TA sites requesting TA will receive tailored services based on the needs and goals of their agency. There are a multitude of different services you can request. You can request basic resources, information. You can request us to review your self-assessment tool submission. You can request to adopt one or more of the guidelines. We tailor it to what your agency needs. Our TA also offers peer connection opportunities for increased engagement and learning from other selected sites. To fully implement the national guidelines, it is important for agencies to examine data from a race equity lens to ensure that tools are being used appropriately. Receiving our TA will help establish your agency as a leader in the field, and we truly want agencies to be able to share their experiences with peers to assist other agencies with adopting the guidelines. To request our technical assistance, you can visit the Take Action tab on our webpage, which I will drop that link as well, or you can do so right now by scanning the QR code on the screen. Once you're there, simply follow the links to the TA request form, and then you can submit your request. Next slide, David. If you're not applying for technical assistance, there are so many other ways for you to become involved. You can review the suite of resources available on the website that were designated for a variety of audiences. You can take the self-assessment to evaluate the status of your agency's efforts. You can sign up for our newsletter just to stay up to date on any opportunities and future resources for the project. And lastly, for any and all TA-related questions, you can either submit a request for TA or reach out to any of our project members, and we would be more than happy to assist you. Thank you so much for your time. I will now hand it back over to David for the Q&A.
So just a couple of things that I'll mention. One is I just want to restate the fact that it is a choose your own adventure, meaning that I don't want people to feel like, oh my God, there's 13 of these and we can't possibly approach this next year or whatever. It may be that you can only approach one or two. And I want to reiterate that. It's very important that people do what they can do. And part of what we do sometimes in our technical assistance is work with folks to say, what can you do in the next year? What can you do 2 years from now, 3 years from now, et cetera. So that's one. Two is, to be clear, the technical assistance is supported by the Bureau of Justice Assistance. There is no cost to the states for this. Thirdly, it takes, depending on the level of involvement, and that will depend on the request, we would be involved with folks for up to a year in terms of doing the work, potentially even longer. And the only reason that I'm saying potentially is because we can never request that till it gets to the end of that first year. So I can't promise that, but generally speaking, that works out pretty well. Meaning that we get approval in order to do that and to move forward. Lastly, we gave you an overview of the 13 guidelines. Each one of those guidelines has numerous subsets, hence the 50 pages. We don't do that for general presentations because, one, it would take all day, and two, unless you're the person who's going to be absolutely in the weeds doing the work, it is too much information that you don't need. But for those folks here who might be doing the work themselves, or if you are going to be asking one of your staff to do it, that 50-page document really goes into deep depth about what each one goes into depth about what each one of those guidelines means and how to get or reach those guidelines. With that, we have said what we have to say. If there are any questions, we are more than happy to respond to those questions. If there are not, that is fine as well, but you should know that you have our email contacts from the invitation, and at any time you can feel free to reach out to us. And we hope that some or another of you might reach out for some technical assistance. There is no deadline. It is it's what we call rolling submissions, which means that we take them as they come in. And if somebody wants to apply next week, we will meet with them. If somebody wants to do that in 6 weeks, we will meet with them then. We very purposely have set it up as a rolling deadline because one of the things that we frankly learned when we started this, when we had a very specific deadline, was that it wasn't fair to the states, that what they had to do to do that turnaround was just too tight. And so we got permission from BJA to make them rolling deadlines so that, if a state is in the middle of a legislative season, they aren't stuck because they can't get it in 2 weeks, that sort of thing. And we will be continuing to take applications at this point, as we understand it. We'll be continuing to take applications until June of next year, so June of 2025.
David, beyond Massachusetts, what are some of the jurisdictions you're working with maybe for the folks on the call?
Sure. We are working with the state of Minnesota and their multiple delivery systems. We're working with New Jersey, specifically at looking at the issue of specialized risk and need assessment of females in their female facility, their prison, female prison. We are working with San Diego, who's looking at issues about how do you do risk and needs assessment when you have people. This has to do with the resentencing laws and folks who were sentenced to lifetime and other kinds of things as juveniles, et cetera, and they now have the ability to argue for resentencing. Well, what do we do with those folks? How do we look at that? We're working with Montana, who are really looking at improving some of their work in terms of their parole assessment and decisions. And we are at the very beginning stages of working with Arizona in some of the things that they are looking at the court level. And we have also had we also have some initial applications or reach outs, if you will, from Rhode Island and from, who am I forgetting? Nebraska. And there's a third one, that I just can't remember off the top of my head. So we have several states, and one of the things that I have been appreciative of is that we're getting requests from all sorts of states, blue states, red states, purple states, whatever color state you want it to be. We're getting requests from all of those different states, and that's actually really very important that it's happening that way. I would hate to have it be just one group of states that is interested.
Yeah, no, and it sounds like too, you've got a nice mix of kind of unified statewide systems, but also some like local county systems as well. And
Yes.
which is good. At least for the membership of NAPE, we kind of, range from just that large statewide systems to, county systems on that end. Folks are taken care of.
For sure.
Yeah. What are you finding as far as the gender specific kind of tools go? I know you're working in New Jersey. Is it with the WRNA?
Yes, it is with the WRNA. Really, the only and the only gender specific tool, and one could argue it's gender informed even at the WRNA level, is the Women's Risk Need Assessment. And that is indeed what we're working with one of the co-developers of the tool to get this going in New Jersey, because they're starting at the very beginning with this. They currently, New Jersey does not use risk and needs assessment in any of their facilities. Their probation system does, but their correct or DOC system does not. We also have just started a small project with the University of Utah and Emily Salisbury and her folks, one of the co-creators of the WRNA, to do some additional piloting of the WRNA, which will have to be renamed, but of the WRNA with men, because the next generation of risk and need tools need to include a trauma component for men, not just for women. We are just seeing very clearly how this is a major issue within the criminal justice system for those people incarcerated and or on supervision. And so I think that I don't want to see this thing where we go from risk needs to trauma and we drop risk needs. I think that's a mistake. I do want to see, how do we get better than a 25% reduction in criminal behavior among higher risk individuals? And the way to do that is to think about what's missing in what we're doing, not what do we get rid of, but what do we need to improve what it is that we're doing. And I think that one of the major things about that is that improvement, again, as I mentioned earlier, in understanding the responsivity issues and particularly in understanding the trauma. Because if we aren't dealing with those issues, it doesn't matter how good our COG work is, it's not going to get through. It's going to get blocked. They've already, they had a small pilot in Nevada and a small pilot elsewhere with the WRNA, and we're looking to really expand some of that over the next year or so and be able to begin to, whether it's called the Myrna or it's called the Mowerna, or it's got a whole new name altogether, but really looking to, because again, anybody, if you're familiar with the Women's Risk Need Assessment, it has all the criminogenic factors that a risk assessment for men has. It's added the components about trauma. And so there certainly is no reason to think that it shouldn't be predictively valid. But again, we need to be looking at that and validating that on male populations in order to assure that. The initial pilot studies have been quite promising, frankly.
I can't say I'm surprised to hear that. That's great.
So with that, it's 3 o'clock. Again, certainly happy to, if there's any other questions. Otherwise, we will let people get back to their very busy lives and the work that they're doing. And again, hope that we might hear from 1 or 2 folks in the future, not too distant future, perhaps, in terms of perhaps getting some additional technical assistance with folks. And again, what we're doing is very different in Massachusetts. It has to do with revalidating a tool. In Minnesota, it has to do with an initial validation and decisions about who and when the tools are, who the tools are used for and when. In New Jersey, it's a starting from scratch project. In 2 of the states, their long-term goal is to meet all 13 guidelines. In the 3rd state, that's not what their long-term goal is at this point, because they just have to get things off and started, and hopefully down the road they will move from there. So there's lots of different ways to look at and to approach TA, and we're more than happy to talk with folks about providing that. It is, again, a very simple process. Complete the self-assessment tool, contact us. We set up a phone call or a Zoom meeting, and we will chat about it. And again, we'll get you this link, Brian, so that those folks that were unable to make it, that indicated they did want to hear more about this, can take a look at that at their leisure, and we'll hear everything we've just said, including the ability to apply.
Awesome. Thank you so much.
You are very welcome. Take care, everybody.
You
Be
too.
well.
Have a good one.